Thank you for coming up here as quickly as you have. This is, as we are all at this time aware, time for oral argument in cause number 1 CV150476, Stafford versus Burns et al. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen technical problems, you can critique yourself on YouTube in a couple of weeks and see how you think you did. Counsel, each side will, as I know you're all aware, be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking up all of your time. However, ultimately, your reserving of rebuttal time, is up to you. We have reviewed the briefs and conferenced the case this morning, so we're well aware of the facts and issues attendant to this argument. You might want to keep that in mind in the course of your addressing the court this morning. And counsel, for each of you, when you come to the podium, I would ask that you state your name and who you represent. And with that, appellant's counsel, you may begin.
Good morning. In response, I'd like to try my best to reserve 8 minutes. If I go over that in response to questioning, I'll do my best to keep it short. Elliot Greisen on behalf of the plaintiffs, the Stafford family in the trial court below, and the appellants in this trial court. In following the court's instruction from the case that was just argued, the meat of this appeal is really the first two issues that we briefed to the court. The first and most important is the proper jury instruction on burden of proof that should have been given in this case. The burden of proof instruction is the very foundation of any trial. It is a appeal dispositive issue in this case. If the wrong burden of proof was given, it's plain error, and we believe under a long string of cases in almost every jurisdiction, a new trial is required. In this particular case, we have ARS section 12-572. It's plaintiff argument to this court that plain words in the setting of this statute specifically state that the clear and convincing burden of proof only applies to acts and admission done in the emergency department in compliance with EMTALA.
Counsel, I may not have heard you right. Did you say acts and omissions?
Acts and omissions.
Thank you.
That are done in compliance with EMTALA. And EMTALA is a federal statute and has been subjected to many various court decisions. In this particular case, to our research, which we believe to be adequate, we don't believe the Arizona court has taken a position on this. And that is why we think it's an extremely important case to give guidance to the trial courts. It has the position that we argue is very similar to a number of cases that we briefed, and I'm not going to go through them all unless you have specific questions about them. But what we argue to you is that the Arizona legislature could have very easily, if it intended to, could have applied the clear and convincing standard for all actions that occurred in the emergency department by simply stating that in plain and simple language. And that would be consistent with what the Georgia legislature did. And we've provided to you the Georgia statute, which makes it very, very clear that everything that happens in the emergency rooms, all of the cases that arise out of actions or omissions in the emergency room, in those cases, the clear and convincing standard should be applied and given to the jury. The Arizona legislature decided not to, and so we are now left with the language of the statute and the clear, repeated, well-established law in Arizona that says when the language is clear, we are not going to try to look at legislative history. We're not going to try to delve in. We're going to follow the clear language of the statute. So what does the statute say? It's very clear that it applies to a health professional, and I'm reading directly from the statute, who provides who is consulted to provide services to a patient of a licensed hospital in compliance with the Emergency Medical Treatment and Labor Act. So when does that act apply? EMTALA was put into place to prevent patient dumping, and we have several pages on that in our brief. It was put into place to require when every patient comes in, regardless of insurance or ability to pay, every patient that comes in gets a medical screening examination to determine if a medical emergency, defined as a serious threat to the person's life or bodily injury, and if that medical emergency is found, then treatment to stabilize the patient has to be given before you transfer the patient to another hospital or inside the hospital where you admit the patient.
Or release.
Released. Sure, it could be released, but if they're released, if they stay in the hospital or they stay in the emergency department, once the screening exam is done and determines that there's not a medical emergency, then EMTALA no longer defines what has to happen. It is not for all care that's provided in the emergency department or the hospital, because if it was, the Arizona legislature would have adopted exactly that language.
Well, counsel, does there have to be some sort of physical or medical distress evident at the time the person comes to the hospital before EMTALA applies? And if so, wouldn't that prejudice everything that followed if it was misunderstood?
The answer to that is no. It has to follow the definition of the EMTALA medical emergency, which is a serious threat to life or bodily function. It is not just distress or every patient. What does apply, Judge Jones, is when every patient comes in, you need a medical screening to be sure it's safe. If the medical screen decides there is no threat, there is no emergency as defined, then EMTALA stops right at that point, and it does not go on. Dr. Burns' actions in this case were completely outside of EMTALA.
But Dr. Burns wasn't the first doctor to even treat when he showed up, so how can you then imply or put the import of the decision by the first doctor on Dr. Burns as to whether or not EMTALA was even applicable under your definition?
Under this definition of EMTALA, the screening exam was conducted by the first doctor, Dr. Kessing. He determined that a medical emergency did not exist, that there was no immediate threat. Therefore, EMTALA-related care stopped at the end of that screening examination. The screening was done by another physician. We never sued Dr. Kessing because he would have been held because he was doing the screening. The screening is the first examination that's done. That's the whole goal of EMTALA, to screen them immediately and see what needs to be done. There was no determination of an emergency medical condition, and in fact, Defendant Burns, in all of her testimony, during the trial at least, insisted that this was not a medical emergency. EMTALA plays no role, if I can answer this question as directly as I can. EMTALA plays no role in this case, none, because Dr. Burns did not provide services in compliance with EMTALA. she provided services several hours later after it was determined by Dr. Kessing that a medical emergency did not exist. 2, the pleadings nowhere mentioned EMTALA. 3, the 78-page joint pretrial never mentioned EMTALA. There was no EMTALA mandated care in this case after the screening exam was done. EMTALA was never designed to be a new statute that applies to all medical malpractice cases in emergency rooms or in the hospital.
Counsel,
Sure.
could you help me? Where is it in the record that the first doctor said there was no medical emergency?
I believe it's in his deposition because there was no treatment needed.
But where is it? I mean, is there a record number? Is there a deposition page number that was presented at trial?
I think the portion that I would refer you to is that Dr. Burns testified in her trial testimony that there was no medical emergency.
Well, but is she referring that she didn't think there was a medical emergency, or that she was saying that Dr. Kestig, is that?
Kessing, what I believe was his name, and her testimony was that there was no medical emergency, and I believe in our brief we cited her testimony where it reflected the fact that she viewed this as a mild overdose that was not a medical emergency.
I understand that,
and no treatment was needed.
I understand that.
Yeah.
I guess I'm getting to the preface of that. If a patient presents to the hospital and the first doctor who examines them says, hey, I've got a medical emergency and we're going to treat, and then that doctor goes off duty and and they're treating and they haven't released him yet, they haven't transferred him yet, they haven't admitted him yet, second doctor comes in and says, I don't see this as a medical emergency. I understand your point about the second doctor, but the first doctor has already said there's a medical emergency, and that's why the patient is still in the emergency room. And I'm trying to get to where you're saying that Dr. Kessig said this is not a medical emergency.
As I understand your question, if the Dr. Kessing had determined there was a medical emergency, which was an immediate threat to life that needed immediate treatment, then EMTALA would apply until which time that patient was stabilized and was then either transferred to another hospital or admitted. So once he's stabilized, EMTALA would no longer apply.
Actually, my question was simply, where in the record is the statement, the evidence that says Dr. Kessig said this is not a medical emergency as defined by EMTALA?
I do not believe Dr. Kessing's testimony was ever taken, his deposition was read or anything like that. The place in the record I would refer you to is Dr. Burns' testimony. Also, I believe in the brief of the appellee here stating that she did not view this as a medical emergency. She reviewed it as simply her job was to determine the discharge. So my answer to that question would be, once the patient is determined not to be a medical emergency, EMTALA stops.
It's an interesting argument, because if you have the first doctor saying, and I'm not saying this happened, but I'm saying theoretically, the first doctor says, I've got a medical emergency in my hands and I'm going to treat the person until he's stabilized and I either admit him or release him or transfer him. And then a second doctor comes in and says, well, I don't think there's a medical emergency here, and decides to release the person and is wrong, then where does EMTALA stop?
It stops when the emergency has been stabilized sufficient to transfer and there is no longer an immediate threat to the patient's life. That's when it stops.
I was under the impression that EMTALA continued through that process.
Absolutely not, Your Honor. Our answer to that is no, and the case law is clear. To trigger EMTALA, the hospital physicians must recognize that there was a medical emergency and the patient has an emergency condition. These cases we cited to you in Bryant versus Adventist Health Systems West and Baber versus Health Corporation of America.
When does it end? I mean, the question is, I mean, if you have a patient, let me just raise it, let me articulate my question for you. if you have the patient who's now stabilized but not yet released or transferred or admitted, does EMTALA end then because that's when he's stabilized? Or what happens if he's stabilized but they haven't yet released him?
It ends when he's stabilized and the medical emergency no longer exists.
And which is your best case on that?
Those are the two cases I cited to you, Bryant versus Adventist Health Systems West and Baber versus Hospital Corporation America, both discussed in length in our brief.
Okay.
And as far as Dr. Casing's record for the screening, David was kind enough to help me. It's in the joint pretrial statement, pages 2, paragraphs IR 490.
Oh, that's a little slower. I'm sorry. Page 2.
Page 2, paragraphs IR 490. What's IR?
Paragraph 5. IR is index of record.
Index of record 490. Thank you, David. The transcript GS 4 through 8 from the 21st of January, the trial date, and IR 641, and the deposition of Dr. Casing, which is in the record at 551.
Counsel, you're going to have to I'm writing this down as you're talking.
Okay.
So we have record number 490.
Do you want me to hand you David's notes, or would that make it
Sure.
my approach?
Save everybody time. Yes, except for you.
I'll hand it.
Mr. Abney's handwriting will become a matter of public record.
Mr.
now.
Abney, maybe you could rewrite this and give it to.
I will certainly do that.
If you'll do that while we're doing this, thank you.
Are there any other questions on the EMTALA issue? Because we believe that is the most important issue. We believe that it requires a new trial. We believe that if you look at the language of the statute, apply the clear and plain rule that's been endorsed by the court numerous times in numerous decisions, that it's clear not to meant to everything that occurs in the emergency room, only to what is in EMTALA, or if there's a disaster. I mean, if a disaster, hundreds of patients come in, you would also give the clear and convincing standard.
Given that you have limited time and you have 8 or 9 arguments, I think, to make, or some portion thereof, how can you best use your time, counsel?
Let me just do 1 minute on the striking of the juror, and then I'll save 3 minutes. The juror's strike should have been automatic. I was there every day, so the judge gave the juror admonition multiple times during the day. Sometimes the whole admonition, sometimes just a paragraph or 2. Sometimes he would just say, remember the admonition. Still, after 10 days of hearing it 4 times a day, the court reporter came back and said, juror number 10 is talking in the elevator with other jurors. That should have been automatic. As a matter of fact, when we first heard it, we had a hearing, and the judge said yes.
Did you insist that the juror be removed?
I did, absolutely. Every time I had an opportunity, multiple motions to ask that the juror be removed, because then you avoid the appearance of impropriety and any chance of prejudice. And the judge originally agreed with me, and so did the defense attorney, if you read the transcript. We all agreed we were going to remove him. The next day, for reasons I'm not sure, but for reasons the trial court decided not to remove him. There were 2 alternates left. The jury was going to be instructed. The safest, almost automatic thing should have been to strike this juror and bring in, and we still had 2 alternates, so the trial would have gone forward without any question about whether he could follow the jury instruction. And that's the argument I made to the trial court. If you don't follow an admonition that's been given 40 times, how can you be expected to follow the rest of the jury instructions? And I'll reserve the rest.
Thank you.
Thank you.
Good morning, Your Honors. Eileen Gilbride for the defense. I actually was going to start my argument with the jurisdictional issue, but if you don't want me to address that, I'll go right into the EMTALA issue. Is that something you need me to address?
No, I don't.
Yeah, I
There
think
was
I'd
a-
rather hear the EMTALA issue, frankly,
Okay.
if you're going to spend the time on it.
Okay, sounds good. There is no reversible error in the clear and convincing instruction, and here's why. The statute, ARS 12-572, is called burden of proof for treatment in emergency departments or rendered by on-call providers. It says the clear and convincing standard applies to health professionals, we have that here, who provide services, we have that here, in compliance with EMTALA, and we have that here. And that's exactly what Dr. Burns did. She provided services to Jesse Stafford in compliance with EMTALA.
Did anything happen before Dr. Burns got on the scene that would have prejudiced the claim that EMTALA did not apply?
No. In other words, no one is making a violation of EMTALA claim here. No one is claiming that the hospital violated EMTALA. All we're trying to do is determine whether the clear and convincing statute applies.
But let me ask you this way then. I'm sorry for the way I may
Sure.
have been obtuse in the way I asked that. Did the doctor who saw
Kessing, or
did Dr.
No.
Kessig say that there was no medical emergency and therefore the hospital was off the hook as to all medical emergency issues?
he did not say that. He didn't testify at trial that I know of. His testimony is certainly not in the record. And if he had thought there was no emergency or no emergency medical service, he would have discharged the guy before 7 a.m. when Dr. Burns came on.
Well, I generally understand your point. Sometimes, though, people show up at the emergency room for the strangest of reasons.
This is true.
They may have cut their hand.
Right.
And it's not a life-threatening situation.
Right.
And they get screened.
Yep.
And they say, we'll get to you. We'll give you a stitch or two, but it's going to take a while. Mm-hmm. And EMTALA may not apply in that situation, even though they're still in the emergency room.
It does, and I'll tell you why. Because it applies whenever someone comes to the emergency room and requests services. That's when it applies.
Right.
And it requires the screening, it requires the determination, it applies to that.
Right.
It applies all of the time that plaintiff or anyone is saying that they're not stable.
Right, but what happens if, and this may not be this case.
Right.
What happens if someone has cut their finger?
Right.
It's on a Saturday afternoon. They can't go see a doctor. They say, I got to get some stitches. They go to the emergency room. Emergency room does the screening.
Yes.
And so EMTALA applies because they've been presented.
Mm-hmm.
They say, this isn't an emergency, a medical emergency. If you want to stay, when we can get to you, we'll put you in the line and we'll stitch up your hand. But this is not a medical emergency. Would EMTALA still apply simply because they're sitting in the emergency room?
So it's the service to which EMTALA applies, not a time frame. Mm-hmm. So the time EMTALA applies to the request, to the screening, and to the treatment until he's discharged or admitted or something else. And whether I understand is an interesting sort of theoretical discussion about when EMTALA ends. That doesn't apply here. We honestly don't have to discuss it here because here plaintiff is claiming that Jesse was not stable. He was not stabilized. He was discharged too early. And so clearly EMTALA applies.
You're indicating that we don't have to worry about the outlier.
That's right. That's right, because this is
not that
this
case.
is not that
Okay.
case.
Okay.
His mother brought him in. He had symptoms of substance abuse overdose. He had told her he had taken this substance, methadone. And the regulations, the CFR, define emergency medical condition to include symptoms of substance abuse. And that is CFR 42 CFR 489.24 B.
Really?
B1. Well, it's emergency medical. It's the definition of emergency medical condition.
But I thought B says the hospital is required only to perform such screening as would be appropriate for any individual presenting in that manner to determine the individual does not have an emergency medical condition.
Now, are you looking at the CFR or the actual statute?
I think I'm looking at the CFR.
Because I have B definitions as used in this subpart, and it starts with capacity, comes to the emergency room, and then it has emergency medical condition means. It's the it's the fourth page in. A medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, psychiatric disturbances, and or symptoms of substance abuse, such that the absence of immediate medical attention could reasonably be expected to result in.
We may have
you know,
missed that. Okay.
Yes.
It may have been, we may have been looking at the USC and not
Yes,
the CFR.
exactly,
Okay, we can check
exactly.
that.
It's in the regulations that.
So you're saying as a matter of regulation, it didn't require a doctor's interpretation. As a matter of regulation, it was a medical emergency.
Well, it was a medical emergency by Dr. Kessing's conduct, by Dr. Burns's conduct. If it hadn't been a emergency medical condition, they wouldn't have observed him for 11 hours in the emergency room.
I figured that's where you were going with this.
Yeah,
Okay,
you don't have to have, an evidentiary hearing to determine whether or not it's an emergency medical condition. They took him in, they hooked him up, they gave him, treatment. They had a 2-hour psych exam. This is all in compliance to make sure he was stabilized before he was discharged. I don't know how the plaintiff can say, you discharged him too early, he was not stabilized, and argue this was not an emergency medical condition. It doesn't make sense. It had to have been. And it was. You don't have to prove that there was an emergency medical condition, though, in order for the statute to apply. All you have to do is say this is a service that's covered by EMTALA. They came, they asked for the treatment, they got it, they made sure he was stabilized, they sent him home.
So he was stabilized from something.
He was stabilized from his drug
But
overdose.
from the circumstance that constituted the apparent emergency at the time he arrived.
Right.
Well, I mean, I could sort of understand the argument that, let's say, the first doctor comes in and says, I've got a medical emergency. Or doesn't say it, but it's covered by EMTALA. They stabilize the person. First doctor goes off duty. Second doctor comes in and says, well, I'm looking at the person. We've already stabilized him. We can release him. Gee, I see something else, but I'm not going to, this isn't under EMTALA anymore. And therefore, there's a common law cause of action. I mean, we're only talking about a common law cause of action. And therefore, it's a breach of the duty it's a negligent medical malpractice action not subject to the EMTALA because the person had already been subject to release or transfer. I mean,
I hate to disagree with you, but the the application of the statute does not depend on whether the guy shows up with a really bad overdose or a kind of bad overdose, or whether he's sort of stabilized, or whether we kind of need to give him a couple more hours to make sure. Right. It applies to the service.
When does the statute end? Does the statute end when they make a determination
when
you can be released, or when he is released?
I think it's when he is released, and I believe that's in the CFR also. Okay. It says that EMTALA applies to the services until he's discharged or transferred or admitted or something's done with him. That's when it ends. And then again, we don't have to worry about that in this case.
But if he is subjected to the ever-present situation where they can't find a doctor to sign the release papers at the time he needs to, that he is stable, and it takes another 2 hours to get someone to come in and sign for him to get him out of there, EMTALA applies throughout that period?
Not positive. They're claiming he wasn't stable. He wasn't stable at all, and that's what the basis of this complaint is. He wasn't stable, so EMTALA applies. It has to. If you need more argument on that issue, I can go on. There is no abuse in keeping juror number 10. There was no affirmative showing of prejudice, which is something they needed to do in order to show that there is some reversible error here. He got on the elevator. He said, I wonder, why this or why that. Nobody responded. Nobody said anything more. He told the judge. The judge asked him directly, have you said anything else? Has anything else occurred? He said, absolutely not. That's just not an abuse of discretion. Really, I don't see the need to discuss any of the other issues. I don't think they're reversible at all. If you see any issues, I'm happy to discuss them. I will go back real quickly to the offer of judgment issue, the jurisdictional issue. We don't need to? Okay.
That Rule 68 issue?
The Rule 60 issue.
It's, unless one of the other judges is interested, I don't need to hear argument on that.
All right. Well, unless you have any other questions, I'll just ask you to affirm the judgment in our favor then.
Thank you, Counselor.
Thank you.
Thank you. Looks like I've got 237, so if this is some critical point you want me to talk about, otherwise I'll just summarize what I found.
I would like you to address
Please.
Dennis's argument that how can you say EMTALA doesn't apply if you're claiming that he was not stable and therefore should not have been released?
And I can address that exactly, and there's good federal law on exactly that point. She misstates the law. Once the doctor decides that there is not an emergency medical condition that is as defined, even if this decision is wrong, and in fact there was an emergency, EMTALA does not apply. And the cases I would cite to you on that are, and we briefed them, mentioned them in our brief, Moses, which is a Sixth Circuit case of 2009, and it does, I believe, cite Roberts, which I believe is a Ninth Circuit case in this analysis. And what they say in Moses is if a hospital physician does not believe an emergency medical condition exists because they wrongly diagnose the patient, EMTALA does not apply. And EMTALA applies to the medical screening that takes place and the stabilization of emergency medical conditions. And once that is done, EMTALA no longer applies, and by the words of the statute, the physician or provider is not afforded the protection of the higher burden of proof. And your analysis was exactly on point. And although you used the cut finger, there could be a lot of other examples. There'd be almost all of the care in the emergency department that doesn't involve a medical emergency that needs immediate treatment is outside the scope of EMTALA. EMTALA, as I think you grasped when we discussed it before, and EMTALA addresses this patient dumping, and they wanted to stop it to ensure that every patient, even if you didn't have insurance, no matter your status, would get this minimal level of care. It was never designed to cover everything that occurred in the emergency department.
Actually also applies to pregnancies.
And pregnancy. We didn't talk about labor, but since Jesse wasn't pregnant,
It was part of the reason for the statute.
It was probably safe to go there.
They didn't want pregnant women being dumped on the street if they did just because they didn't have insurance.
Absolutely. And in that sense, once the doctor decides the patient is stable, we didn't sue Dr. Kessing because he would be covered by that. There is no emergency medical condition. He did arrange for psychiatric screening to be sure they had follow-up and some counseling outside, but it had absolutely nothing to do with EMTALA. And that's why we argue the preponderance of the evidence was the proper instruction that should be given. If the legislature decides that's not what they intended, they can go back and enact the Georgia statute, which clearly, I wouldn't be up here arguing if Arizona had the Georgia statute. And over and over again in Arizona law, and I think on federal law too, we're starting to recognize that we're safest when we just look at the language of the statute, and if it makes sense to the court, don't go beyond that. Don't go into the area of all these legislative history and the attachments to the appellee's brief. You don't have to go there. I think you can look at the statute, apply the plain and clear language of the statute, and see that unless EMTALA care is being provided, medical screening, stabilization of emergency conditions, everything else in the emergency room gets if I allege a medical malpractice case, the jury gets the instruction on preponderance of the evidence, not clear and convincing, highly probable. I mean, if I thought that, I probably wouldn't have even taken the case. I mean, that's a very difficult standard to convince a jury of. Preponderance, a little bit more, 51%. Then the plaintiff perhaps has an opportunity to win. But clear and convincing is a very tough hurdle to get over. And in that type of setting, if the legislature decides to follow Georgia and says everything in, at least I know that that's what the instruction is going to be given. This statute clearly says it has to be in compliance with MTAL. Thank you so much.
Thank you, counsel. And all counsel, we appreciate your argument. You may have noticed we are extremely interested in this issue, and the underlying statute. MTAL is it's an issue. So we are going to take it under advisement at this time. We will rule in due course. Thank you for your time. Thank you for your argument.